Ready, start. This intra-court appeal arises out of the judgment of Honorable Single Judge dated 27/5/2004 in writ petition number 15313 of 1998 dismissing the appellant's writ petition against the order of recovery, which is being sought to be made from his pension and gratuity on account of excess payment of salary when he was in service. Stop para. We have heard learned counsel for the petitioner appellant as well as learned standing counsel for the respondents. Stop para. It appears that the appellant was appointed on 15/12/1956 as health visitor in the pay scale of 354-550. Stop. In the year 1994, the pay scale of rupees 470-735 was given to the multi-purpose health workers and others with effect from 23/7/1981. Stop. Consequently, the petitioner appellant was paid the difference on account of enhancement of the scale by virtue of the aforesaid government order. Stop. However, the aforesaid government order was subsequently set aside and was modified by another government order dated 23/5/1995. Stop. The petitioner appellant in the meanwhile retired after attaining the age of superannuation. Stop. Now, after lapse of several years, respondents by the impugned order dated 19/1/1998 have sought to recover. Stop para. It is submitted that the aforesaid benefit of revision of pay scale was granted by the state government by issuing a government order pursuant whereto payment was also made. Stop. If the state government has subsequently recalled or withdrawn the aforesaid GO, the benefit which has already been extended and granted pursuant to which payment was already made cannot now be recovered. Stop para. On the other hand, learned standing counsel opposing the prayer vehemently contended that since the GO itself by which payment was made has been recalled by the state government, the petitioner has no right to draw the revised pay scale and payment has rightly been sought to recover. Stop para. We are of the view that the contention of learned counsel for the petitioner appellant has substance in view of the law laid down by the apex court as well as this court in the judgments relied upon by learned counsel for the petitioner appellant, which have been followed by this bench also in special appeal number 1317 of 2003 MD oblique Chief Engineer UP Jal Nigam and others versus Srinath Singh and others connected matters in which this bench has held as under within inverted comma in the matter of recovery, we may remind to the authorities that now it is well settled if certain payment has been made to the employee on account of any fault of the employer, and for which the employee is not responsible comma, namely, comma, not guilty of fraud or misrepresentation, comma, in such a case, comma, the amount which has already been received by the employee and he has spent, comma, should not be recovered, stop, inverted comma, close, para, we, comma, therefore, comma, are of the view that the honorable single judge fell in error by dismissing the writ petition merely on the ground that in the case of Shyam Babu Verma and others versus Union of India and others 1994, 1 UPLBEC within bracket 54, stop.